Okay, good afternoon, everybody. Thank you very much for joining us this afternoon. My name is Martin Butcher. I am Senior Counsel at Jacobowitz and Gubits. I practice bankruptcy law and family law. And we are going to go through today the pros and cons of bankruptcy for individuals and small businesses. This is part of our webinar series that we've put together to present. We have other upcoming seminars. On July 14th, we have landlord and tenant law, and on July 21st, we have estate planning. Those webinars, or links to those webinars, can be found on our website, jacobowitz.com, under the events tab. We have you all muted just so we can get through this presentation. If you do have a question, feel free to put it in the chat section of Zoom. It'll pop up on my screen and we can answer them. We're going to try to answer the questions towards the end of the presentation, so we can just get through the material that we have today, and then we can spend some time answering questions, if that's okay. All right, so let's start. Jacobowitz and Gubits, it's a full-service law firm. We've been in business for over 50 years. We're the largest law firm in Orange County. We have over 20 attorneys and we practice over 35 areas of law. So we can pretty much cover anything. If you have any kind of legal question, we can certainly help you out or find the answer for you. So the presentation we're going to go through today is on the bankruptcy for individuals and small businesses. We're going to start with an introduction to bankruptcy. We're going to then discuss the signs that you may be ready for or maybe in need of a bankruptcy petition. We'll talk about the process that we have here at J&G, and we'll go through chapters 7 and 13, which primarily link to or used by individuals. And then we'll talk about chapter 11 as it relates to small businesses. We will talk about the options that you have available besides bankruptcy, and then we'll provide some general advice if you are considering bankruptcy. Okay, so as an overview to bankruptcy, when we're talking about bankruptcy for individuals and small businesses, we talk about the main three chapters, chapters 7, 13, and 11. So chapter 7 is primarily for individuals. It can be used by sole proprietors, but primarily for their personal debt. It's a liquidation plan, which is where the trustee will take the assets that are available and will use those assets to satisfy the debts that are incorporated within the bankruptcy petition that we file. Chapter 7 is now incomes means tested, and we'll talk about that in a little moment. Chapter 13 can really be used by anybody from an individual through to a large corporation. It's a restructuring plan rather than a liquidation plan, in that you get to keep the assets as long as you can afford them, and you work towards a repayment plan with the trustee to satisfy the debts that are incorporated within the petition. This does not have, chapter 13 does not have an incomes test, which is why it's an alternative to chapter 7 for individuals. And with regard to chapter 11, when we're talking about chapter 11, we're talking primarily about chapter 5 for small businesses, which has recently, very recently been amended. It was amended last year and it came into effect in February of this year, which was very serendipitous for the current situation that we're all facing. This is chapter 11 is used by companies. Individuals cannot file under chapter 11. And it's for people looking to stay in business and to manage their debt to allow them to continue operating. And again, as chapter 13, it's a restructuring plan that will allow you to pay off the debts over time with the trustee to satisfy as much of your creditors as possible, but to allow you a clean state to move forward and work your business as needed. So just to go through some signs that you may be ready to file for bankruptcy, you know, the primary one is life events that have caused financial struggle. And those life events, you know, many people will know, obviously COVID-19 is the big one that we're all thinking about now. And we do anticipate a significant increase in bankruptcy filings over the next few months. But also we're talking about, you know, illnesses, whether it's sort of through reducing your ability to work and the income that you receive, or whether it's the medical debts. Those are life events that may cause you financial struggle, along with divorce and things like that. Another sign is if your savings or retirement assets have been spent trying to keep up with the debt load that you have, in trying to make the monthly minimum payments. And if you have spent your savings and your retirements and you're now relying on credit cards, that's another sign that bankruptcy should be a consideration at the very least. Similarly, if you're borrowing from one source to pay back another source of credit, if you're using one credit card to satisfy the minimum payment on another credit card, you know, that could be a red flag. And then certainly if you have debt collectors calling, or if there's a foreclosure or eviction proceeding, bankruptcy can help you deal with the creditors, deal with the foreclosure sale, deal with the eviction to allow you some breathing room to get you back on your feet. And then overall, the biggest sign is if your finances are causing significant stress to you on a daily basis. You know, nobody should be struggling with the stress of dealing with their finances to the point it impacts your life significantly. So bankruptcy may be a consideration at that point. You know, as I said, to give you some breathing room to reset all of your credit card debts or your medical loans or bills, and to provide a fresh start to move forward in your life. Okay, so the process here at Jacobowitz and Gubits, we start with an initial consult with the paralegal. They are very good here. The staff that we have at this firm are extremely efficient and knowledgeable. And we start with the consult with the paralegal to really establish whether you are a candidate for bankruptcy, whether there could be an option that you may not have thought of or looked at that may benefit you more, because we're really not looking to add to your financial struggle. We're looking to help you as best that we can. And if that's not going through a bankruptcy proceeding and that's taking some other route, as we will discuss towards the end of this presentation, that's what we're looking to do at the very earliest opportunity. Then we will send you over to a credit counseling service or a program, which is a requirement before you file for bankruptcy. You have to have attended some sort of credit counseling within 60 days prior to filing. So that's a good opportunity to do it after the initial consult with the paralegal while we're working up, you know, the incomes test if we're looking at a Chapter 7. And then we're going to go through everything with the attorneys and figure out, you know, what options you have available to you, whether Chapter 7 is appropriate, whether you need to file under Chapter 13, whether bankruptcy is the best option for you overall. And then we try to see how we can help you move forward, either through the bankruptcy proceeding, as I said, or through credit counseling or debt workouts with your creditors. After that point, you retain us, we'll prepare the petition, the bankruptcy petition, and we will file that. We have a software program that we use, which keeps track of everything. It helps us guide the clients through the process, and we can use your input onto the program to generate the forms that we need to fill out and file. Then we would attend any conferences and hearings with the bankruptcy court and the trustee, and then we will provide you guidance through to the discharge of the bankruptcy proceeding. Okay, so the primary chapter under which people file individually is Chapter 7. Over 60% of bankruptcy filings are under Chapter 7, with over 90% of those being discharged, oftentimes within 6 months. So it's a very quick option if we're looking at secured or unsecured credit card debt, which it's just beyond your ability to repay. It's cheap in that the filing fees are pretty low, and the time spent with the attorneys and filing the papers and having to go to conferences is minimal in comparison to some of the other chapters, as we will discuss in a moment. The benefit of filing for bankruptcy, and this is the same for all chapters, whether it's 7, 11, or 13, is that an automatic stay will come into place upon the filing of the petition. Now, the automatic stay prevents your creditors from taking certain actions that will impact the estate of the bankruptcy, which is in your assets, your income, and all of that. So if there is a upcoming eviction, it will prevent that eviction from going forward. If there's a foreclosure action that has been started, it will stay that foreclosure action until the bankruptcy has been discharged or dismissed by the bankruptcy court. So it's a very good way. It will stop creditors from calling you. It will stop enforcement of judgments. It will stop garnishments. It will not stop things like child support. Child support proceedings can go forward. But if it's, other forms of family law, if it's the divorce itself, the divorce will be stayed until the stay is lifted or the petition is discharged. Certain property is going to be exempt under Chapter 7. So there is going to be, there's New York state exemptions that will allow you to keep a share of the equity in the house up to a certain amount. And it depends on the county that you're living in. So for Putnam, Rockland, and Westchester, it's up to $170,000 that you can keep in equity in the house. For Orange, Dutchess, and Ulster, it's $140,000, and for all of the other counties in the state, it's $85,000, give or take a few dollars. And those amounts change every 3 years. You can also keep equity in cars that you have. So if you have a vehicle and you owe less than it's worth, you can keep a certain amount of that equity. And there's ways to deal with the cars, even if it's over that amount of equity. You can keep tools of the trade that you need, and you can keep certain value of your jewelry. And again, things like pensions, 401ks, IRAs will also be safeguarded under bankruptcy petitions, whether it's a 7, a 13, or an 11. There are certain property that are not exempt, so things like a second home, an RV, a boat, that sort of thing, you cannot exempt, and those are the assets that will be taken by the trustee and used to satisfy the creditors as much as possible. But once we've dealt with the Chapter 7, and you've gone through that process, and you've dealt with the trustee, and the trustee is confident that there are no hidden assets or there's no income out there that they don't know about, and that they've done the best job that they can for the creditors, you will have a clean slate upon discharge. The debts that you've included in that petition will be discharged. They won't appear on, they won't be able to come after you for those debts. That will be it. But, unfortunately, there are downsides to a Chapter 7 as well, which is, as a result of those debts being discharged, there's going to be a significant impact on your credit. Now, the bankruptcy filing itself will remain on your credit for 10 years. But that does not mean you cannot get credit during those 10 years. It will take a period of time, maybe 3, 4, or 5 years, but as long as you have a discharge and you are acting responsibly after that discharge, you will be able to rebuild your credit to the point where you can get financing for a car or you can get a mortgage. Certainly, there will be an impact upon the interest rate. As you go forward from the point of filing onward, the interest rate will be substantially higher than otherwise. But as I said, over the 10 years, hopefully that interest rate drops as your credit score improves. In talking about the exempt property, I touched on the non-exempt property. So that is the second home, the RV, the boat, and things like that. Unfortunately, those assets you cannot keep and will have to be used to satisfy the debts and pay back the creditors to the full extent that they can be. You know, things, even inheritances that you receive or cash gifts that you receive during that period of filing, those can also be taken by the trustee and used to satisfy your debts. There are certain debts that cannot be discharged. So income taxes cannot be discharged. Child support, arrears cannot be discharged. And, you know, everybody has heard that student loans cannot be discharged. And then there's limitations to Chapter 7. So under Chapter 7, as I have mentioned, there is an income's means test. If your income is over a certain level, you are ineligible to file for Chapter 7. Now, for a single person in New York, the income's mean test is based on the median income for your family size. So for a one-person family, for a single person, it's $55,000 a year or more. For a family of 4, it's $107,000 or more. Now, with that being said, it's a two-stage test. So if we look at your income on a monthly basis over the last 6 months, and the court decides that your income is over the median income for the state, we can then go to the second step of the test, and we can deduct from your income certain expenses that are allowable by the Bankruptcy Code. So you're allowed to deduct personal expenses, housing expenses, and transportation. Now, the problem with those 3 categories, and just to touch on them, the personal expenses are clothing, food, that sort of thing. Housing is obviously mortgage or rent, utilities. Transportation is commutation expenses. The Bankruptcy Code uses averages for those 3 categories. So it's not based upon the expenses that you personally have. It is based upon the average that they have determined for that period of time. And that's what's deducted from your income. But on top of that, you get to deduct other expenses. You get to deduct taxes that you may pay, involuntary deductions. So some people may have union dues through their employment or have to contribute towards their retirement plan. Those can be deducted. So health insurance and life insurance can also be deducted, as well as court-ordered payments, so child support, maintenance, that sort of thing. So that with those deductions, the hope is that we're able to bring the qualifying income down low enough that you can use Chapter 7, even if your income is above the threshold for Chapter 7 under the income's means test. And again, that's all something that we work through with you when we're intaking the case and you're speaking with the paralegal. That's part of the role that they have in looking at the income and looking at the pay stubs that you bring in and all of that, and deciding what is your income on average and whether you meet the requirements, and if there are expenses that we can use to lower that income. So on to Chapter 13. So having discussed the means test to some extent, Chapter 13 is where there is no incomes test. So this is where you are over the incomes means test for Chapter 7. But there is still an issue that you cannot pay back your creditors, and you need the assistance of the bankruptcy court. The idea is that you move from a Chapter 7 to a Chapter 13 filing. Now, under Chapter 13, this is a restructuring chapter. So we're looking to restructure your debts to allow you to pay them in a period of time, over a period of 3 to 5 years, based on a number of factors. This chapter allows you to retain the assets that you have, so you wouldn't need to give up the RV or the boat or the second home as long as you have sufficient income to satisfy the debts that are secured on them. You have to be current on your mortgage to keep the house. You have to be current on the car loan payment to keep the car. All of that can be worked out as part of a Chapter 13 payment plan if you are behind in those payments, but you do need to make the payments. You don't get the house free and clear of a mortgage just because you file a Chapter 13. So the benefit of a Chapter 13 over a 7, besides the fact that you get to retain your assets, would also be that there's less of an impact upon your credit score. The thought being that you're making your best efforts to repay based on the income that you have available to you, and that you need some assistance in restructuring the debt, and that has less of an impact than if the debt is discharged entirely. It will have some impact still, but it's less of an impact than Chapter 7. The downside, obviously, to a Chapter 13 is the disposable income that you have is going to be directed towards the debt. So the way this works is, in filing the petition, you have to come up with a payment plan. And the trustee will go through that payment plan and will look at your income and your expenses to determine what your disposable income is. Now, it's complicated as to how that plan is arrived at. So that could be the subject of another 30-minute seminar on itself. But the idea is that you establish what are your basic expenses that you have, what is the income that's over those expenses, and that disposable income is paid towards the creditors. So it is quite an onerous challenge that you have there, and that payment plan can last between 3 and 5 years. So you will be having a focus very clearly on maintaining a consistent budget each month to be able to make those payments in a timely fashion to the trustee and to the creditors to meet the plan that was put in place and agreed to by the court. Because of the reporting requirements and the oversight that is needed through the trustee, it's more expensive than a Chapter 7. The filing fees are about the same, but it's just that there is a significant amount more work in preparing the plan and meeting with the trustee and ensuring that the plan is being followed, that leads to the expenses going up. And similarly, because you're waiting 3 to 5 years to make all of those payments, it's slower to discharge than a Chapter 7. So you do not have that immediate relief beyond the automatic stay that clears out your debts and allows you to start afresh. However, we go back to the fact that you get to keep the assets that you have, and you don't have to sell everything that you have in your possession. So that's the upside to the fact that it's more expensive and it's slower to discharge. And finally, the other point to raise in terms of the cons for a Chapter 13 is that there are no second chances. Now that means if you do not follow the plan, the trustee can seek to dismiss your bankruptcy petition. You would then be limited for a period of time for filing again under Chapter 7, and you will have a harder chance getting an agreed to payment plan in a Chapter 13 filing. There are ways around it, and that's part of our job as attorneys, your attorneys, to ensure that even if you have failed to meet the plan, if you are struggling, that we get an amendment to the plan, that we get some forbearance from the court, and we get you back onto the right track. But it really needs to be stressed that the Chapter 13 does require you to sit and ensure that you can meet the terms of the plan that is put together over the 3 to 5 years before you enter into it, because there is an impact that's going to be had if you are unable to do that. So those are the Chapter 7 and Chapters 13 that primarily apply to individuals. We're going to move on to Chapter 11, which is available to small businesses. In fact, businesses of all sizes, but we're going to focus on the impact it has for small businesses because that's the primary employer in this area, the small business. So we are looking at a restructuring plan again. This is not a liquidation plan as under Chapter 7. We're looking to restructure the debt of a valid business that can operate at a profit if it gets some assistance in dealing with the debt that has been accrued. Under subchapter 5, which is where the provisions are for small businesses, as I said at the beginning, subchapter 5 was amended in 2019, I'm sorry, and was came into effect in February of this year, right in time for the COVID crisis. So under subchapter 5, you are now permitted to retain control of the business. You can continue to operate it as a going concern, provided you can show to the trustee that there will be a profit at the end of the day, that you can make things work, but you just need some assistance with the creditors. Previously, that was not the case. The trustee may come in and control the business, but you get to now retain the assets of the business and to use them to run the business. Payment plans previously needed to be approved by the creditors, which created quite a significant hurdle because obviously they have an incentive to require much higher levels of repayment than maybe the business could afford. So now with the revised subchapter 5 provisions, payment plans do not need to be approved by the creditors. And if needed, the court will step in and enforce that, the repayment plan, and allow you to proceed with it. And then one big disadvantage with a chapter 11 subchapter 5 filing previously had been that if debt had been secured against a residence, a personal residence of one of the business owners, and they used that secured credit line to finance the business, that loan on the personal residence could not be modified. So the terms could not be modified as part of a Chapter 11 filing. Fortunately now, and I think it's going to be a very significant change, is that we're now able to modify the terms of any loan that was secured against a personal residence that was used primarily for the business. So it can't be just a primary mortgage that was used to actually purchase the residence. It has to be something, you know, a loan, a personal loan that was taken out to benefit the business, to purchase tools, and was secured against a personal residence. If we can meet those requirements, then we're able to modify the loan so you're not losing that personal residence on top of the business and the income that was generated from that business. So that's a significant change. The disadvantages: there's a limitation to the debt that you can discharge under a Chapter 11 filing. It's 2.7 million. And again, that's both secured and unsecured debt. So that's the mortgages that were secured on the personal residence to finance the business. That's equipment loans, you know, so, you know, you have tractors and trailers and all of that sort of thing. Those debts are going to run up pretty quickly. So there is a limitation. However, I would say, you know, with the assistance that was provided under the COVID acts that were passed, that limit has been increased to 7.5 million for the short duration that we're in this current crisis. Similar to a Chapter 13, it's more expensive and it's slower to discharge. You know, again, you're looking at a 3 to 5 year window, a payment plan before the discharge will be granted, and the filing fees for a Chapter 11 are significantly higher. And there's also a percentage of the repayment that has to go to the trustee. As I mentioned, you have to show a reasonable expectation that after the bankruptcy, the business will be profitable, which, you know, is the hope, which is, you know, we really hope that we can rebuild these businesses and move forward and rebuild a profit. But the court needs to see that we're not throwing good money after bad, unfortunately. So we do need to show that there is going to be a return to profitability. And then obviously there is going to be involvement of the court and the trustee into compensation for the business owners and for the key personnel in the business, as well as court oversight on operations of the business that may be outside of the ordinary day-to-day business operations. So if you come across a lucrative opportunity that may be outside of your general business practice, you would need to get permission from the trustee and from the court to pursue those opportunities, which can present a hurdle if you're trying to move fast and take advantage of an opportunity. But again, we're looking to resolve issues with creditors so the business can continue and you can return to profitability and you can move on with your life and the use of the business. So having gone through the three chapters that we can file under for both individuals and for small businesses, there are other options that can be considered outside of bankruptcy. There is the creditor workout, so we can contact the creditors and see if we can arrange a deal, maybe there's a lump sum that they would accept for a credit card or a medical bill that is significantly less than the current balance owed. Maybe we can consolidate a loan, or we can seek to get that loan refinanced. Really, it would be down to you to refinance it, but with our assistance, we have contacts that we work with on a regular basis that may be able to provide financing or some restructuring of debt outside of bankruptcy to benefit you. And then there's the credit counseling agencies, but you have to be aware of these agencies. In my mind, they operate very much like having filed a Chapter 11 or Chapter 13 restructuring plan, but you do not get the benefit of the discharge at the end of the program if you don't go through that plan. And you fall out of the plan or whatever it may be, you're not going to get that discharge. And you're also going to have to pay all of the debt back to the creditors under the plan, rather than paying over only what you can and then getting the discharge from the bankruptcy. So that's a consideration. And there's also some that may not be reputable, and there's issues like that for credit counseling agencies. So just to wrap up the presentation, we want to give you some advice if you are considering a bankruptcy. The primary one is going to be gather financial documentation. So there's going to be a lot of information that you need to provide to a bankruptcy attorney in preparing the petition. You're going to need to show the proof of incomes, so pay stubs, checks if you're working for yourself and you're getting paid through invoices. You need to show those invoices. We need to show 2 years of tax returns. We need to show statements for bank accounts, for credit cards, for medical debts, all of the things we want to include in the petition to discharge. We need to be able to document it if in case the trustee comes back to us and asks for proof of those debts. We also need to establish what the actual amount of the debt is that's owed, so we can include that amount in the filing. And then we need to collect any documentation related to any foreclosure actions or collection actions by any creditors. We need to avoid taking on any new debt if possible. Certainly any debt within the 6 months prior to filing. The trustee can go back and look at any debt that's incurred and can claw back any money that may have been taken from a loan and used in a way they see unfit or improper. So we need to avoid taking on new debt. As we had talked about, the exempt assets, the pensions, the retirement accounts, the 401ks, the IRAs, all of those are exempt from being taken under a Chapter 7 bankruptcy. So we don't want you to raid your retirement accounts. That money should be left to the side. As for your retirement, it shouldn't be used to satisfy debts if you're considering a bankruptcy in the next few months. There's no point in taking that money out of a retirement account that would be exempt and giving it to creditors when they wouldn't get it otherwise. Most importantly, we need you to be truthful to whoever you retain to assist you in your bankruptcy. the trustees do look at everything, and they will ask questions. There are questions that they ask at the creditors meeting where you have to appear and you have to answer these questions. If they sniff any sort of fraud or attempt to hide assets, or you've transferred some jewelry to a friend, or you've tried to hide a car in your friend's garage, something like that, they can and do find out about it, and there will be severe ramifications if and when they find out about it. So the most important advice we can give you if you're looking at bankruptcy is to be truthful with whoever you retain to assist you in filing that bankruptcy petition. So that's really the presentation that we have for you this afternoon. Here is our information. As I said, we have the webinars coming up. July 14th, we have landlord and tenant law. And we will go through all of the aspects of landlord-tenant as it relates to the COVID crisis, as well as estate planning and asset protection. That's on July 21st. Again, the webinars can be accessed through our website, jacobowitz.com/events. If you would like to join our mailing list, we've put out a newsletter for our clients. Again, we would direct you to the website, jacobowitz.com. And then here's my information. If you want to send me a question, if you have any comments, if you have any concerns, if you want to ask a question, having thought over the presentation this afternoon, please feel free to contact me. My email address, msb@jacobowitz.com. That's for Martin Stewart Butcher at jacobowitz.com. The phone number here, 845-764-9656. You can reach me there or at my email address. And we're located in Walden, just outside of Montgomery, and in Monticello up in Sullivan County. So we have the chat function available if anybody has any specific questions. We have the chat function. Feel free to send me a question through that chat function, the Q&A, I believe it's called. Otherwise, I thank you very much for joining us this afternoon. I hope the presentation was informative and useful, and we look forward to helping you in the future for bankruptcy, for estate planning, whatever it may be. Have a great afternoon, and I hope you all keep very safe and very well. Thank you. Let's see, was there, yes. Okay. No problem, Camille. I hope you enjoyed it. All right.